So this is Unit 3, Part 2. A security guard who exceeds their authority could be subject to a civil lawsuit and criminal prosecution. Civil lawsuits may seek money damages from both the company and the security guard. Violations can also include criminal penalties. Under the theory of respondeat superior, an employer may be responsible for the acts of an employee when the employee is acting within the legitimate scope of their authority. So I have to pause here. This is very similar to something we've learned back in law enforcement. In law enforcement, the police department is responsible for what the individual officers do, good or bad. And if it's bad, the police officer can be held responsible, but so can the police department. And in that setting, we call it vicarious liability. Vicarious liability. Liability through the actions of that one individual carries over to the department. So respondeat superior is the exact same thing. Two different words means the same thing. Respondeat superior, vicarious liability. So an employer may be responsible for the acts of an employee when the employee is acting within the legitimate scope of their authority. So meaning the company allowed or directed the security guard to do certain acts, then that company is held responsible too. A security guard who does not act properly could be subject to reprimand and or loss of employment. You can get fired from your job if you do something you're not supposed to do. Of course, that's true anywhere, isn't it? A security guard may be accused of negligence by both the company and the person suing the security guard and the company. Compensatory damages, so compensate. You can see the word compensate and compensatory. So compensate money, that's what this is, which can be assigned, involve payment to a person for injury sustained because the security guard acted or failed to act. So, and then the other kind of money is punitive damages. Punitive, and you can see the word punish. Punitive damages are awarded for several reasons, including fraud, oppression, malice, or wanton conduct. Punitive damages are damages having the character of punishment or penalty. So here's a scenario, and this is, I think, pretty true. You are a loss prevention security person for Walmart. The law allows you to make an arrest for felonies that it didn't happen in front of you, but as long as it turns out to be true, you can make that arrest. The law gives you that power. However, Walmart, as a private company, may say to you, we don't want you to put hands on anybody. We don't want you to you can make an arrest, but if they run, you have to let them go. You can't put hands on anybody. That's our rule. The law says that you can, but our private company rule is we don't want you to do that because there's too much liability. If you end up wrong, we're going to get sued. If you end up doing something wrong, that there's big problems that can come. And so let's say one day you're working and you see somebody shoplift what you believe to be, well, first of all, if you're seeing it happen, you can make that arrest right there because you saw it with your own eyes. But you have to be sure. You can't, like there's a lot of scenarios. It's like, well, were they actually stealing it? Were they just moving it? What were they doing with it? At what point did you know you had probable cause for the theft? What was the value of the item? Did they attempt to leave the store without paying? All of these things come into play. But let's say that occurs and you approach the person and you tell them to stop, that they're under arrest, and they take off running, and you go against Walmart's policy, even though the law says you can, and you chase this person down, you tackle them in the parking lot, and you break their arm during the struggle, they're going to sue you, and they're probably going to sue Walmart. And so this money that they're talking about, compensatory and punitive, compensatory is the actual dollar amount that you cost that shoplifter with their broken arm. There's medical bills, there's pain and suffering. Maybe they couldn't go to work because they had a broken arm, so they lost a paycheck. So they'll add all that money up, and that's if they win the lawsuit, the compensatory damages is going to be all the dollars added up that they lost because of your actions. The punitive damage is just to punish you for doing something wrong, and that money goes to the person who's suing you. So there's two groups of money, compensatory, punitive, and that's basically what they are. So let's keep going here. So, possession of a firearm or other weapons. Security guards may carry firearms only with the clear and direct permission of the employer. Armed guards must possess a valid New York State pistol license and their New York State Armed Security Guard license. You must have completed your 47-hour firearms training and then your 8-hour annual in-service training. And we talked about this back in Unit 1. Possession of firearms or other weapons. Security guards may use aerosol subject restraint devices, pepper spray, that is designed for civilian use for defensive purposes only. And this is out of the law book. This is not private employer rule. This is out of the penal code in New York State. So we talked about how civilians can get mace, and police officers have oleoresin capsicum, OC spray, pepper spray, and the strengths are very different. Well, they're talking about here, you may carry mace. You will not carry what the police carry for pepper spray. And number 4 says security guards are not permitted to possess or use impact weapons. PR-24, the baton, the asp, those are police weapons, and a security guard may not use those. And it goes on to talk about metal knuckles, chukka sticks, billy clubs, blackjacks, bludgeons, police batons, etc. You're not allowed to have any of that as a security guard. Factors supporting an arrest, and this should all be really pretty familiar with you guys. A lot of it's similar to what we talked about back in law enforcement. Your physical evidence, you want to have a chain of custody. Your confessions, they need to be written, signed, and witnessed. Your fingerprints and photographs, they need to be readily discernible. That means not blurry, clear to see. Identifying the defendant, keep the person who's making the ID present. Your personal observation by security guard, that's absolutely a factor in supporting an arrest. And information that you get from other police sources. If it's information other than police sources, use caution. What is the motive of this person telling you this information? How honest are they? How sincere are they? You have to demonstrate the reliability of the person making the identification and the informant's basis for knowledge of the crime. So how do they know about this? What did they see? What did they hear? Where were they? what is their connection to any of it. I'm not going to spend a whole lot of time. This is, again, review for you guys. So an offense is conduct for which a sentence or a term of imprisonment or a fine is provided by any law of this state, local law, or ordinance of a political subdivision of the state, or by any order, rule, or regulation of any government instrumental authorized to adopt the same. So an offense includes violations, misdemeanors, and felonies. A violation other than is an offense other than a traffic infraction for which a sentence or term of imprisonment in excess of 15 days cannot be imposed. And usually it's just a ticket, an appearance ticket. But this is what we call those ordinance violation, local rules. Then we get our misdemeanor and our felony. And the definition is basically the punishment. So for a misdemeanor, it's an offense other than a traffic infraction for which a term of imprisonment in excess of 15 days may be imposed, but for which a sentence to a term in excess of 1 year cannot be imposed. So the maximum punishment is a year or less. That is the definition of a misdemeanor, and the definition of a felony is for any offense which a sentence for a term of imprisonment for more than a year may be imposed. And this is review for you guys. So I kind of explained this already. I hope to go through this fairly quickly. Arrest without a warrant by any person when and where authorized. And this is in the New York State Criminal Procedure Law, Article 140, Section .30. For a felony, when the offender has, in fact, committed such felony, a felony did occur, and that person is the one who did it. And any offense for when the offender has in fact committed such offense in their presence. You saw it with your own 2 eyes. You're good to go. So, arrest without a warrant continued. Felony arrests may be made anywhere in the state. Arrests other than a felony may only be made in the county where committed. Standard of proof, in fact committed. No hunch, guess, or even reasonable belief may support an arrest. The legality of the arrest is based on whether the offense was actually committed by the person arrested. And like I said, sometimes you don't know that right away. Arrest without a warrant by a person acting here's our new category. For the procedure for taking a person into custody. So arrest without a warrant by a person acting other than as a police officer or peace officer, when and how. And again, this is part of the new criminal procedure law. A person may arrest another person at any hour of any day or night. They must inform the person whom he or she is arresting of the reason for such arrest unless he encounters physical resistance, flight, or other factors rendering such procedure impractical. So they want you to say you are under arrest for, and then tell them what for. You have to say the words, you're under arrest. So that they know, so that they can't say later, I didn't know what he was doing. He was trying to grab me. He was trying to, he was touching me, and I didn't know what the heck was going on. So to avoid that, you say the word you're under arrest, and you tell them why. If, of course, they start to fight you immediately, or they try to run immediately, that's a little bit impractical, but you should do it as soon as you can. So you may use physical force pursuant to the Penal Law Section, Article 35, Section .30. You may use physical force to defend yourself, to defend a third party from imminent use of deadly physical force. So imminent means immediate. 2, you may use physical force to effect the arrest of a person who has committed murder, manslaughter in the first degree, robbery, forcible rape, or forcible sodomy, and who is in immediate flight of the crime scene. This is what we call the fleeing felon rule. So you may use force to defend yourself or a third party at any time. But you can also use force to apprehend someone who's trying to run away if they did one of these crimes. And these, of course, are our most serious felonies that we have. And the logic behind it is if they were to get away, somebody else could be killed, raped, murdered, etc. Security guards should make every effort to avoid using force and just liability, guys. So the procedure to follow up an arrest without a warrant by a person acting other than a police or peace officer. This is again Article 140, Section .40. You must, without unnecessary delay, deliver or attempt to deliver the person arrested to the custody of a police officer. The security guard is still the arresting officer, but the police are the administrative side of it. They are the ones who will fill out the booking sheet and take the fingerprints and the photograph and put that into the system and write out an appearance ticket for court. But you have to go to court to prosecute your case. This is really important. Applicability of Miranda warning. Miranda warning applies to police custodial interrogation. The Miranda decision is directed at law enforcement officers and does not apply to private citizens, which is what security guards are. So, security guards do not and will not read Miranda warnings ever to people or suspects or arrestees. Miranda only applies to law enforcement. Security guards must make all required court appearances related to an arrest. Your case will get dismissed. If you don't go to court to tell the judge what you saw and what happened, it's going to get dismissed. You are the arresting officer. You are the complainant and all of that. The police don't do that for you. So, summary. We're finally done. I know this was a little long. So you should feel pretty comfortable with the origin of the security guard's arrest authority and the liability that they have. List the factors that support an arrest, define a felony and a misdemeanor, and describe circumstances when arrest without a warrant is authorized by a security guard. Describe proper procedures for taking persons into custody who have been detained by security. List the circumstances when a security guard is authorized to use physical force. List the circumstances when a security guard is authorized to use deadly physical force. List procedures to follow upon arrest of a suspect. And that's it. So this quiz, you're going to have like 24 questions. Go back through the material and really review this stuff. I talked really fast because I didn't want the video to be too long. Okay. Bye.